Someone just asked me a question on Facebook about vacation rentals, if I heard anything. And that would be interesting if he addresses that in that, you know, all we heard was what he said. We haven't seen the order. That vacation rental ban's got to be one of the dumbest things.
Hey Ryan, no, we cannot see you. You were sent an invite as a panelist. You need to make sure you select that link so you can log in. If you've not checked your email, make sure you do that. I think you're logged in as an attendee right now instead of a panelist, so we can't see you. As for everyone else that's attending, we're going to get started promptly at 2:05. I just want to give everybody ample time to get logged in. We'll jump right in. We got a few admin things. We got our affiliates on board, and we got a very impactful hour-and-a-half seminar webinar here that we're excited about. Lots to go over. We're excited to hear Harry Heist take on it and all the updated news that's coming down the pipe. We'll get started in about 2 minutes. There we go. There's Ryan.
Am I able to share my screen, Daniel, when I talk?
You should have that ability, yes, when it's your time. At the bottom of the window, you should have a green share screen button. Hey, Ryan. All right, it's 2:05. Let's get started. We've got a lot to get through, and as they say, never enough time to get through it. So first of all, welcome to today's COVID-19 Legal Seminar. My name is Daniel Rothrock. I am your Tampa Bay president, presiding over the Tampa Bay chapter here, 2019 and 2020, and I'm super excited to have everyone on board. had over 100 registrations for today's event, and certainly appreciate everybody that's taken their precious time away to come and learn about all the changes that are taking place in our industry. So first and foremost, thank you for doing so. Today's event is being broadcast on our Tampa Bay NARPM Facebook page, and it's also being recorded for your convenience. We'll be sure to share that in as many social ways as we possibly can so that you have the information in front of you. Today's event is also brought to you by our Tampa Bay Emerald and Platinum sponsors. We've got 5 of those: Harry Heist of Heist, Weisse, and Wolk, Ty Swinson of the Maintenance Pros, Scott Wilcox of Dry Right, Ryan James of Liberty Adjusters, and Lisa Jordan of Accent American. And in just a few minutes, we're going to hear a few things from them. But before we do that and hand over the reins to Harry, I just want to talk about a few things from an admin. First and foremost, if you're not a NARPM member or an affiliate, I highly recommend you getting involved. In times like these, NARPM has been a tremendous asset to the property management industry. And for those that are heavily involved in NARPM, you get it. For those that aren't involved in NARPM, you know, hopefully you're not struggling, but we hear a lot of the common questions for those that aren't part of NARPM, network. So NARPM is foundation on relationships and education. And so if you can imagine right now, that's more imperative than any time that we've seen in the last few years. So reach out, ask some questions. I'll post some things in the chat regarding NARPM. And if you have any other questions about getting involved, I can certainly make sure that you have all that. We've got a couple events coming up, and I'm just going to talk about 2 very briefly. First and foremost, we have a marketing event. This is a virtual classroom. It's a 2-day class. NARPM Nationals has split this into 2 virtual days. It's half days, and it's essentially from 9 a.m. to 12:30 p.m., I believe. It does start on May 19th. So if you're looking to get more information about how to market as a residential property manager, you can find that information on our website. And again, I'll post more details on that. The second course, which is our normal luncheon, is our tech panel. Now that's on June 18th. And at this time, we do not expect to necessarily be back in a physical setting at that. Ironically, with it being a tech panel, what better way to do that than over a virtual Zoom meeting or something of that sort. So that information will continue to be shared out here shortly. But again, we do not expect to be back in a physical setting by June. We do hope to be back by July. So lastly, just want to point out, please post all of your questions in the Q&A section and not in the chat. Harry will not be monitoring either section, but I will be monitoring the Q&A section, and we will leave plenty of time at the end of this session to make sure that we go over any questions at that time. So without further ado, we're going to jump right in. I'm going to give Ty Swinson with the Maintenance Pros his speaking opportunity. Ty, the floor is yours. Feel free to share that screen if you'd like.
No, it won't let me. I'll just talk.
Okay.
As you can see, we're open for business. Still working 24/7, 365 here. It doesn't matter what's going on in the world. All my guys, have been given gloves, masks, so if the customer requests that, we'll wear whatever PPE that they request. They're all equipped with plenty of wipes and sprays to sanitize everything that they touch. Your tenant safety is the most important thing to us. We've also been installing a lot of air purification units in people's houses. That stuff will kill viruses, mold, things like that. That's in the air. The big particles will get trapped by the large filter, and then the rest of the stuff will get hit by the UV light. So a lot of people have been putting those in their house now, just to make their air cleaner. They say something like over 50% of illnesses are due to poor indoor air quality. So if you want to, get on that train, we're more than happy. I've probably been doing about 6 of those a week right now, and I'm more than happy to do about 100 a week. So just give us a call, 813-373-PROS, the Maintenance Pros. We're here, we're ready to work, and we're not scared of getting sick because we're around poop all day. So we're good to go. Thank you, guys.
Yep, we appreciate you. All right, next up, Scott Wilcox of Dry Right.
Hey everybody, Scott Draward here. First, hey, thank you for doing this. I'm sure all the property managers Really appreciate this. I'm always happy to get involved and see everybody. 2020 has been a crazy year. We're supposed to be celebrating 40 years here at Dry Right. We opened the doors in 1980 and we're still open, so that's not a problem for us. We are your local experts for your water damage emergencies, your mold removal, air quality concerns. We do all that. Back in 1980, we started as a little old carpet cleaning company, and we still have that division going strong. So we are also your carpet cleaning experts. I'm gonna leave it at that. A lot of you know what I do. You can check us out on the web, like our Facebook page, but we are here for you 24/7, 365. Scott with Dry Right.
Awesome, thank you, sir. All right, over to Ryan James with Liberty Adjusters.
We are, as everyone else said, we're also still in business, operating. We're considered essential. As far as the virus is concerned, how that's impacting things, we're obviously in an unprecedented time. A lot of businesses obviously not receiving the revenue that they should be, and there's a lot of questions going around business interruption insurance, which is coverage that protects the potential earnings of the insured business while its operations are suspended as a result of a covered peril. And the question is COVID, or is the virus, is the civil authority of shutting down business, are those considered covered perils? And the insurance industry as a whole is basically blanketly saying no, none of that's covered. But if you take the time to review policy language, oftentimes it is covered. But there's a lot of different things going on here. You know, a lot of policies have virus exclusion. So someone says, oh, there's virus exclusion, they kind of give up. Well, depending on how that virus exclusion is written, you may still be covered. So it's very important to have your policy reviewed. Same thing with the civil authority coverage. A lot of insurance carriers are saying, no, this doesn't apply. But again, it depends on how it's written. A lot of insurance carriers are saying you don't have physical damage. And the definition of physical damage is up for debate. There's a lot of ambiguity in a lot of people's policies, and anytime there's ambiguity, that is going to be in favor of the policy holder rather than the insured, because the insured is the one who wrote the policy. So there's a lot of reasons why you may be covered, even though the insurance company is saying you're not. This is all brand new, and there's a huge learning curve going on across the board. I've spoken to a number of different law firms that specialize in this area. I've spoken to other public adjusters, and we've been on conference calls trying to figure out the best way to tackle this. So I'm not saying that we have all the answers, but I am saying that we have a lot of experience in these areas. We have a lot of experience understanding policy language. And if you want to send your policy in to us, we're happy to review it free of charge and give you our input. You can send that to info@libertyinsuranceadjusters.com. Just attach it to an email with a little bit of a description of what you're looking for, and we'll be glad to take a look at it for you. And then the other piece of this, of course, being cleanup. We're trying to figure out if there's proper protocol. Really, I haven't found any yet that the insurance company is saying is acceptable. But that's also something that we're looking into and trying to figure out the proper measures to clean up. When it's time to open up your business and let people actually come into it, you want to make sure it's properly sanitized. And that also should be covered on your insurance policy.
Awesome. Good stuff. All right. And last but not least, Miss Lisa Jordan with Accent American.
Hi, I'm Lisa Jordan with Accent American. My company is very similar to Dry Right. We were actually partners for many, many years with Bill Campbell, who founded Dry Right. And Ryan, as far as cleanup protocols, the IICRC is working on developing COVID cleanup protocols. They just haven't been approved yet. What my company is specializing in is things like odor decontamination for pet odors, cooking odors, tobacco odors, marijuana odor. We can get rid of most odors in the home and guarantee that they won't come back. We also do, unfortunately, sometimes crime scene cleanup, bloodborne pathogen. We just did one the other day where we had to clean up blood that had pooled on a wood floor. So we handle those unfortunate messes when you run into those. We've been around, like Dry Right, we've been around since 1985. Ken is a IICRC certified master cleaner, master restorer. We also do expert witness work for mold and water damage claims when it becomes necessary. So our tagline is, when you want it dry and clean, you call 621-6015.
Awesome. Great work. Thanks. Thank you again for all of your support. Again, each of these affiliates, they support our chapter. They work hard. You know, it's really tough right now because we don't get the tangible relationship aspect of meeting in our rooms, but highly encourage anyone watching, make sure you reach out to these guys. Hey, each of you affiliates, if I can ask one big favor, make sure you copy and paste your contact information in the chat, post your websites. That way people can grab it, go take a look, and obviously reach out to you when you can. They can see it there. So I think that will help everyone share your
In the chat
information.
or the Q&A?
In the chat, yep. Yep, that'll be public information. So without further ado, guys, there's no doubt COVID-19 has affected us all in one way, shape, or form. Now, what we do with that is obviously up to you on an individual, professional manner. Hopefully, the good property managers are going to take this, they're going to reevaluate some things, and they're going to pivot, and they're going to grow from this. And obviously, on the other end, they're going to be even better property managers. But if you're like me, you have a lot of questions. There's a lot of questions with, you know, can I do this? When can I do this? And how can I do this? And Harry's here today to tell us, hopefully, you know, to clarify a lot of those questions and to give us some insight from a legal aspect on what we can, what we should be doing, what we shouldn't be doing. And so again, so that we come out at the end of this, we keep ourselves safe, we keep our tenants safe, we keep our landlords safe, and we gain in knowledge and wisdom. So without any more being said, I'm gonna turn it over to Harry Heist. Harry, the floor is yours, sir.
Thanks, Dan. First of all, I want to thank our sponsors for sponsoring the class today and sponsoring the NARPM chapter. A huge thanks to Dan, who's been working through all the technical things. You know, we're all learning how to use Zoom and webinar and all that kind of stuff, and it's tricky. Today, I'm going to spend about an hour and 15 minutes on the legal issues of COVID-19 and how it affects you guys on a day-to-day basis, what you can do, what you can't do, and the questions that we have, because a lot of the things are not answered, are not obvious answers, and some things we just don't have answers for. I was looking through the attendee list today, and almost everybody knows who I am, so I don't really need to give any kind of long intro. I've been an attorney since 1989. All I do is work for property managers. I do evictions, I do leases. If you don't know me, if you don't know who I am, I don't know where you've been for the past 30 years, because I'm practically a household name. It's bizarre, but I'm known for doing this weird stuff, which is evictions and things like that. But anyway, today I'm going to try to bring you some information today that you're going to be able to use right now. You may have realized some mistakes that you've made in the past, and then we're going to move on to the future. I want you to take advantage of this time that you have, if you do have extra time, to do things like reevaluating your business, looking at things that you've been doing for all these years, see if you've been doing the same mistakes for many years, see if there's room for improvement. I know just for myself that we decided to take this time to really look at everything carefully in our business and try to make the absolute best of a bad situation. Sometimes having a kick in the butt is not a bad thing. Obviously, this is a terrible tragedy that people are going through right now. People who are sick and dying. But you know, you have to. Life goes on and business goes on. So you have to do the best that you can. And I know that we're using our time wisely. The good news. Let's start with some good news. Some of you already know this, and a lot of you have been following the Facebook groups and the chats and things like that have been going on. So some of this won't be new to you, but things are not too bad right now as far as rent collection goes. April's rent collection was pretty darn high. May's rent collection was pretty darn high. The delinquencies are really low, way lower than a lot of people expected. There was a lot of gloom and doom that we thought we were going to experience, and the truth was, for professional single-family home property managers, notice I said professional single-family home property managers, the delinquencies are extremely, extremely low. Now, there are a lot of other property managers out there, a lot of other single-family home managers, and I work for over 11,000, and that's something I didn't even look at till about 3 weeks ago, I went and I actually looked at our client list. I work for over 11,000 people who manage property in Florida. And out of those 11,000, I can't say that there are more than maybe 500 of them that I would consider professional property managers. The majority of people that I work for, although I work for almost all the professional ones, the majority is made up of the people who manage 5, 10, 15, 20 houses, and this is not their business. This is not what they focus on. And they are accidental managers, or they're mainly salespeople who don't want to let go of the relationship that they have with an owner, and they are renting out houses, they are managing properties, some do finder's fee only, but there's a massive amount of people out there that don't know what they're doing. There's no way to sugarcoat it. They don't know what they're doing. You are in a different category. If you're a member of NARPM, you're already so far ahead of the game. And I hope that if you are a member, you'll be an active member in NARPM, because active members in NARPM end up becoming extremely successful, and then it helps the chapter be successful, and then we get better speakers, better events, and it just keeps going from there. Every successful property manager I know in Florida is a NARPM member. And if that doesn't tell you something, then I don't know what would. So, okay, let's talk about something really basic right now that that some of you have already been doing, but a lot of you haven't. Now, this is not something that you could discuss amongst yourselves. This is what is called mandatory management fees. I'm an attorney, I'm not a property manager, so I can tell you about this. I can tell you that a large percentage of my clients have a mandatory minimum management fee in their property management agreement. So whether there's a tenant in there or not, whether the tenant's paying rent or not, it doesn't matter. The moment the property manager takes over managing the property, a mandatory minimum management fee kicks into place. A lot of property managers wish they had that in there right now, especially for the ones that are experiencing higher delinquencies. Just something to think about. These are things that you learn when you come to the other classes, when you are active in NARPM. You start seeing what other people are doing. Like I said, this is not something we can never agree to something like this. We can't agree to the amount. None of that stuff can happen. But you can see what other people are doing, and you see whether things work for them. So that's a really good thing to have. If you don't have it, you should think about putting it in your management agreement, just so that you are protected for situations like this, and also just for situations when you have vacancies, when you have evictions, when you take over a property and it sits there for a couple months through no fault of your own. There's a fire, a flood, whatever, and you can't rent it out. You should be getting compensated. Property management is an incredible business. You have an incredible amount of liability, an incredible amount of responsibility. And if you don't think that you have a lot of liability, and you don't think that you have a lot of responsibility, you probably shouldn't even be managing property. For any of you today that are managing properties, and maybe you only have 5, 10, 15 accounts, you need to sit down and just think about this. You need to say to yourself, am I serious about this? Do I really want to build a property management business, or am I stuck with 15, 10, 5 accounts that I have to manage because I don't want to lose a relationship, or because I feel like I have to? If you're in that boat, you need to consider getting out and maybe selling your accounts, maybe partnering with somebody else who's taking this seriously. This is no game. Property management isn't a game. And a lot of people play it like it's a game, not realizing what they're doing. And the liability and the problems that they have are immense. During the day, I probably am getting right now between 200 and 300 emails a day. It's unreal. Never in 30 years have I gotten this many emails each day. And almost every single one of them, almost every single one, the person asks me a question about their tenant, about what the rent payment, about anything. And I have to ask them, is the property covered or not covered? And then what I do is I ask that question, and then I wait a little bit. And then the question comes back, and people go, what do you mean? Well, if you don't know what covered or not covered is, if you don't even have an idea of it at this point, that's very dangerous. That means you have been completely out of the loop since March 27th. And you could potentially have been doing illegal things and not even realized it. So that's just one example of staying in the loop and trying to understand things. We've been hit with information from all sides. Facebook, you're getting emails from NARPM if you're a member of NARPM. There's a lot of information out there, a lot of misinformation. You have to sort through all of this stuff. Sort through it and understand it. One of your first steps right now, your very first steps is contact your owner. Whatever way you normally contact your owner, whether it be email, whether it be texting, whether it be a phone call, I highly recommend that you contact your owner, educate your owner, and let them know that you know what's going on, things are under control, things are not as bad as they might be hearing. They hear all kinds of stuff like rent strikes, no evictions, blah, blah, blah. They hear all this stuff. And I really think it's important right now for you to get in touch with your owners in whatever fashion you deem appropriate and kind of get back to basics and let them know you're here, you're managing their asset, they don't have anything to worry about, and if anything happens that you know what you're supposed to do. There's been a big trend over the years to do everything electronically, to not have any contact with your tenants, have no contact with your owners, and all that stuff is very, very important. If you want to grow, you have to use technology. Some things are going to suffer. Relationships often are going to suffer. But I'm telling you that when somebody comes along with some shiny object, with some offer that an owner can't refuse, if there's no relationship built at all, that owner's going to leave you so quickly you won't know what happened. And you'll be thinking, well, wait a minute, I'm doing a wonderful job here. But they don't know that. They don't understand that. All they're getting is the email every month that tells them how much is being put into their account. So just something to think about, to maybe use this as an opportunity to connect with your owners. There's a lot of information that we're going to give you after this class. Dan's going to send you out emails. An email with a Dropbox link that has a bunch of really good information in it. This is serious stuff. If you mess up, you could have serious penalties. There could be class action lawsuits filed. Evictions are going to be delayed. You're going to potentially have attorney's fee issues where a tenant hires an attorney. And I want to chop something down right now. So many property managers think that tenants can't afford attorneys. You don't need to afford an attorney. You do not need to afford an attorney. Just like with a personal injury case, you don't need to pay your personal injury lawyer. There are attorneys out there all over the place that want to represent tenants. And the reason why they do it for free. But they keep billing the hours. And then if they win, if they get a case thrown out of court, if they win, they're going to come after you for attorney's fees. They're going to come after the owner for attorney's fees. And I've seen simple evictions get bounced out of court by these attorneys. And then the owner is stuck paying anywhere between $2,000, could be up to $35,000. I could show you the cases, you won't believe it. But most of you have never experienced that, but it's out there. And it's out there more than ever before. Legal Aid is on top of this stuff right now. Legal Aid is a very big organization. It's not just the local legal aid office that you might deal with once in a blue moon. Legal Aid is a very large organization with all different names, all different organizations, but it's all a big special interest group to try to help tenants in their time of need. And often they try to keep tenants from being evicted. They try to keep tenants from having to pay rent. And they're an extremely powerful force because they have a lot of numbers, they have a lot of time, and they spend time sitting with the governor, sitting with representatives, sitting with senators, and trying to tell them their side of the story. And if we're not at that table, if the property management industry, the business, is not at that table, bad things can happen. We'd have to be very, very aware of what's going on out there. These people are smart attorneys, and they are huge special interest groups, and that's what's driving a lot of what's going on right now. And we're going to get into that right now. Okay, there's a few things going on. Let's go through them. We have three main things to deal with. One of them super easy, and we're going to get it out of the way. The Supreme Court put out a ruling a while back that said that no writs of possession. That's the very end of the eviction. The writ of possession is where the sheriff meets you at the property and removes the tenant, and all the tenant stuff goes out to the street. That's the end of the eviction. That is not going to occur until after May 29th. The Supreme Court said every sheriff's department in the state of Florida cannot execute a writ of possession until after May 29th. All right, well, that's not that far from now, but that's what the Supreme Court did. Will the Supreme Court change that? Will they make any? Will they add anything to that? Will they extend that? We don't know. The next thing to worry about is the executive order by the governor. Now, most of you have been keeping up with this, and I'm going to be preaching to the choir today. The executive order from the governor originally was signed on April 2nd and said that there will be no evictions for non-payment of rent for 45 days from April 2nd. Well, just today, and I just sent this out to a bunch of people, a bunch of NARPM members already got this just now. Just today, Governor DeSantis did a press conference, and he is extending He's extending the eviction moratorium. This just literally happened today. I have not seen the order. All I did was I heard the words out of his mouth. He's extending the order that will have an eviction moratorium for non-payment of rent. From what I heard him say and what everyone else heard him say, he's extending it until June 2nd. A lot of you were in your mind, you were thinking May 17th, May 17th, May 17th. He just said that he's extending it until June 2nd. I have not seen the order. I don't know if he added anything else into it. I have no clue. We're going to find that out probably later today. So we've got the Supreme Court, we've got the governor, and then we've got the CARES Act. And that's a much harder thing to grasp hold of, and we're going to talk about that today. The laws and the orders and all of these things are kind of unclear. If you were to read them, they're a bit unclear. And when things are unclear, they are decided by a judge. And they're often decided in favor of the tenant. Just like in a policy, with an insurance policy, you just heard Ryan say that when an insurance policy is vague, ambiguous, it's going to be construed in favor of the policyholder. Well, the same thing goes with landlord-tenant law. Anything that's vague will gets construed in favor of the tenant. And unfortunately, the federal government is notorious for having terribly vague things. The governor's order was a bit vague, and that's what we're dealing with right now. That's what we have to work with. The smallest mistake you guys make could be costly. You could go out and serve a 3-day notice thinking that everything is fine. You might be a property manager who files your own eviction. And I don't know if you've been watching ABC Action News, but twice now, the reporter, her name is Jackie, she found all these people were filing evictions in Pinellas, Hillsborough, Manatee, Pasco County. Now you're going to say, wait a minute, Harry, you just said there's an eviction moratorium. That's right. There is an eviction moratorium, but people still were filing evictions because the clerk of court, they were taking anything that comes in. They're not the police. So you're going to hear a lot of misinformation. You're going to hear people say, well, wait a minute. I heard that you could file evictions. This process server or the pseudo attorney. And we have these pseudo attorneys especially in the Tampa Bay area. They prepare eviction paperwork and they file it for people. And often they give really terrible legal advice. And they were telling people, oh, you could file evictions. Yeah, they were right. You could file evictions illegally, but the clerk didn't care. The clerk was taking them. It wasn't their job to police the type of eviction that was filed. Okay, let's dive into the governor's executive order, which, as we heard today, has been extended until June 2nd. Applies to every single property, residential property, all different types of residential property. It doesn't matter what kind of property it is. It applies to everything. It says that no evictions for non-payment of rent are legally going to be able to be filed until after June 2nd. No 3-day notices can be given to anybody for non-payment of rent until after June 2nd. If you've already done it, just stop, because now you know. Do not give any notices for non-payment of rent. Do not give any demands for rent for anyone. Anyone, doesn't matter what type of property it is, until after June 2nd. Now, can you serve them anything? Can you give the tenant anything? And the answer is yes, you can. And we have what's called a reminder letter. You don't want to have the situation where it's out of sight, out of mind. You want to let the tenant know, hello, I'm here. You owe rent. This is how much you owe. So we're not going to just sit back, and if a tenant stops paying rent, we're not going to just sit back and fold our arms and do nothing. No, we're going to use what's called a reminder letter. You can find that letter in the link that we're going to send after the class, and also on evict.com. Evict.com's got a ton of stuff. We really did a lot of work real fast and got a ton of information. You go to evict.com and you hit that red little thing up on top, and that'll take you to the COVID section. That's got the notices, the forums, the videos, the articles, all the links, all kinds of good stuff. All right, so no 3-day notices, no evictions until after June 2nd. As far as we know, we don't have the order in our hands, okay? Now, some of you are like, okay, well, that's cool. After June 2nd, that's not that far from now. We could deal with that. We're not going to die. After June 2nd, then we could go ahead and do whatever we got to do, right? Everything's going to go back to normal. The answer is no, it will not go back to normal. It will only go back to normal on certain properties. And that's what we're going to discuss today. We're going to discuss what's called covered properties and non-covered properties and how that all works out. But the main thing is right now, just don't do anything. No 3-day notices, no demands. But I do recommend that you send your tenants some sort of a reminder letter telling them what they owe. No late charges, no nothing, straight rent. Make sure you let them know what they owe, because you don't want them to completely ignore you. And of course, some people are going to ignore you no matter what. So that's what you can do. Now, what about other things, though? I was talking about non-payment of rent. I hope you caught that. I said non-payment of rent. I said it a bunch of times. What about other non-compliances? Unauthorized pets, unauthorized occupants, violation of rules, regulations in a condo association. What about those things? Can you do anything about that right now? Are your hands tied on that? The answer is no. You still can proceed on those types of things. Your 7-day notice to cure, your notices of non-renewal. You're still allowed to do those things. But listen carefully. Just because I said you could non-renew people, and you could file evictions on people for non-renewals, and you could file evictions on people for non-compliances, you can't use those reasons as a backdoor way to get somebody out when the real reason is non-payment of rent. The purpose of the governor's executive order is to keep people from being evicted for non-payment of rent. Now, oftentimes people who have unauthorized occupants, unauthorized pets, they're violating this, that, and the other thing. Often they are not paying the rent. I understand that. And that doesn't mean that you can't file an eviction against them or give them a notice. Just make sure that your motive is pure. Your motive needs to be for the non-compliance, not because they haven't paid the rent. A judge can see right through what you're doing. If you're really doing it for non-payment of rent, a judge can see it. You could potentially lose the eviction. Everybody can see it. You know what you're doing. I know what you're doing. And many people have asked me, they're like, oh, I want to evict this person. And I'm like, well, why? Okay, well, they're doing this, this, and this. They have an unauthorized pet, unauthorized occupant. And then I ask my questions. You know how I am. I ask my probing questions. I'm like, well, how long have they had that unauthorized occupant? Oh, at least 3 months. How long have they had the unauthorized pet? Oh, probably, I don't know, 3 months, 2 months. I'm like, well, how come you didn't do anything about it? Well, I know why you didn't do anything about it. You didn't do anything about it because they were paying the rent. Now, as soon as they stop paying the rent, you get picky. Okay, I get it. I totally understand it. Just remember, the executive orders in place is to keep people from being evicted for non-payment of rent. So don't think you could grab. And I know, I see you grabbing at straws, grab here, grab there. You're like, what could I do to get this person out? They're not paying the rent. So I'm going to dredge up some kind of non-compliance that I think is going to fly with the court. Well, most of you have never even been to court on a non-compliance. Evictions on non-compliances are way different than evictions for non-payment of rent. They're harder. You have to prove your case. And then you could have all kinds of waiver issues. It's a mess. So it's a problem. It really is. You can serve notice. You can evict for non-compliances, for non-renewals. Just make sure that your motive is that and not because they haven't been paying rent. Look at the underlying reason. Why are you jumping on this person all of a sudden? What is the real purpose of what you're evicting for? Non-renewals. Many people right now, they're in month-to-month status or their lease is coming up to the end. Can you non-renew them? The answer is yes, you can non-renew them. Many owners want to sell their properties. We have a lot of situations going on right now where owners are cashing in. You know, prices are high. Owners are like, you know, this is the time. They're listing their rental properties and they're selling your the rental properties. Many of you are losing properties because of this right now. People are selling their properties, and oftentimes they don't want a tenant in there. The buyer doesn't want a tenant in there. The seller doesn't want a tenant in there. Or maybe the tenant who's in there right now is giving you a hard time about showing the property. And you know what I'm talking about there. It's bad enough when we didn't have this COVID stuff. Now you're trying to sell the property and they don't want to allow showings. And then they're saying it's because it's because of the COVID. They don't want you coming into their home. So everything's falling apart. So your next step would be, well, I'm going to non-renew the person. You can do that. You can do that. It's just the non-payment of rent thing. That's the problem. So to be real clear, June 2nd, hopefully is going to be your date. And then you will be able to proceed from there by serving your normal notices and filing normal evictions, just like before, as long as the property isn't covered under the CARES Act. And we're going to get to that. We're not there yet. Now, some of you misunderstood something right off the bat. You thought that in order for a tenant to be not evicted or to have protection under these laws or executive orders or whatever, some of you thought that it had to be COVID related. Like if they had to prove to you that they lost their job, they had to prove to you that they didn't get unemployment. They had to prove that to you. Otherwise, they weren't going to have the protections of the law. Not true. Doesn't matter if the person's a multimillionaire sitting in your house, not paying any rent whatsoever. It doesn't matter. They don't have to prove that they've been affected by COVID. They don't have to prove that they lost their job. They don't have to prove that they didn't get unemployment. Nothing. It applies to everyone. All right. So now, here we are, June 2nd. I almost said May 17th. Now we're on June 2nd. Are we in the clear? The answer is no. This is when the CARES Act is going to be super important. The CARES Act, as hopefully everyone you know by now, that was enacted in March 27th, and that only applies to some properties. And that's what we're going to talk about today, because there's a lot of misinformation about what it applies to. A lot of people thought, oh, it just applies to government properties. It applies to HUD. It applies to Section 8, low-income housing tax credit. And you're right, it does. It does apply to all those properties, but it goes way beyond that. It applies to any property where the financing is connected to the federal government in some sort of way. So, of course, HUD, of course, Section 8, vouchers, that's obvious, right? Totally obvious, you know that. But now for the less obvious. Fannie Mae, Freddie Mac, any loans that are somehow connected to the Federal Home Loan Mortgage Corporation, the Federal National Mortgage Association, you don't realize it, but these loans, when people get loans, they go to the bank, they get a loan, they have no idea what's going on, and then that loan goes into outer space. It's sold, it's moved around, it's securitized, it's borrowed against, it's crazy what goes on. So you might not realize it, but a mortgage could be covered under the CARES Act. So it has to do with the financing, has to do with the type of property. For instance, I said Section 8 or HUD, you know that though. But more importantly, it has to do with the financing of the property. So you need to learn this word inside and out, covered. Now, covered sounds like a good word to some people. They're like, because you think, oh, I have insurance coverage. And people like, they say, oh, yeah, they'd say, what do you mean covered, Harry? Covered by insurance? Covered by a roof? What do you mean? No, learn what the word covered means. Covered means that it's covered under the CARES Act. It's protected under the CARES Act. Your tenant is protected under the CARES Act. So your first big task right now is to find out if the property that you're managing is covered or not. That is going to require some work. What are you going to do? We have a form. You could send it to the owner of the property. Now, I don't necessarily say that you should do this right now. If your tenant's paying rent right now, there's no need to unnecessarily scare your owner, freak your owner out. And like I said, these owners, you should communicate in some sort of way, but you should be prepared, because if your tenant stops paying rent, it's going to be really important to know whether the property is covered or not. So I recommend that you'd start doing some research right now. At least find out which one of your owners owns the property outright. No mortgage, no nothing. If they say they own it outright and you want to confirm that, I could give you a link. There's a title company in Florida that will, for $50, will at least confirm that there is no mortgage. That's all. I mean, you could pay them more money to do other things. Of course, it's not a title insurance company. It's a title search company. So they could at least confirm that for you. They charge $50. You might have a friend in the title business that'll do it for you for free. But right now, you want to find out which one of your properties are not covered. That's the easy part. Which are not covered. And you're going to find out, are they paid off? Is there a mortgage? What's going on? Is the mortgage with a private mortgage with somebody? Is it totally with some little tiny bank on the street corner where there's no connection to the federal government? You're going to find that out. And find out if the property is not covered. Very, very important. Okay, so now you're going to be able to then do that fairly easily. If somebody says my property's paid off, you're going to be able to confirm that. And then you're going to put them over here into this not covered pile. That's the good pile. Right over here, this is the good pile, not covered. And that's great, because not covered is going to give you a lot of flexibility after June 2nd. It's important, though, now with the others who have mortgages, it's important to find out what the scoop is with these mortgages. And we're very lucky in Florida that a lot of people have paid off properties. So you have a fairly good percentage of your properties are paid off, which is very, very good, because that means they're not going to be covered. But with the covered properties, there you are. You got your covered. With your mortgage properties, you need to ask your owner to check with their bank to find out what type of mortgage this is. I'm going to give you a website. There's two websites out there. One is for apartment communities, and one is for Fannie Mae and Freddie Mac. Now, you can't 100% rely on this, but I'm going to send you a link where you could put the property in there, and it will tell you if the property is Fannie Mae or Freddie Mac. Now, Fannie Mae or Freddie Mac makes up the bulk of what covered properties are. but not all of them. So it will help you. I tell people these two websites that I'm going to give you, they will confirm that something is covered under CARES. They won't confirm, though, that it's not covered. So I want you to really listen carefully to that, because some people are like, oh, I looked it up in there and I didn't see it, so they must not be covered. No, that's not true. These websites are not complete. These lookups, the Fannie Mae, Freddie Mac lookups are not complete. If your property comes up, yes, you are a covered property. If the property doesn't come up, that doesn't necessarily mean you're not a covered property. Okay, now where do we go from here? If you're not a covered property, then after June 2nd, you don't have to worry about the CARES Act, because it's not covered. And after June 2nd, you're going to be able to serve your 3-day notices, file evictions, and proceed as normal. But listen carefully on this one. Let's say your tenant hasn't paid rent in May, in April, maybe as far back as March, I hope not. But let's say that what do you've got going here? You've got rent, and you also have late charges. Do not put late charges on your 3-day notice. On June 3rd, if that's our date, on June 3rd, do not throw a ton of late charges on a 3-day notice. We recommend that you keep them all off of there. The tenant did not have to pay the rent. The tenant did not have to get evicted. It could not get evicted. If you put late charges on those notices, you're going to just be asking for trouble from the judge and from the tenant advocate attorneys. Keep it clean. I know you love your late charges. I know it. You live for your late charges. Late charges make you a lot of money. But for right now, do you want to try to collect late charges and then end up having an eviction get blown out of court and end up your owner having to pay $2,000, $3,000, $5,000, $10,000? I don't think so. So as far as late charges go, just chill out on the late charges. Chill out on them. Don't put them on there for your initial once we're back to normal and we've got some tenants who haven't been paying the rent. Do not load them up. Do not put them on, because it'll really cause a problem. I'm not positive that I'm going to file evictions if I see late charges on there without you signing something saying that I told you not to. And you know, I do that sometimes. I'll make you sign something telling you that I'll file a defective. I have filed cases that weren't perfect. I have done that many, many, many times, hundreds, if not thousands of times. I've filed defective. I filed almost 200,000 evictions. So you could imagine sometimes they were defective and sometimes we kind of knew it. We kind of knew it going in, but we decided to take our chances because the chances were the tenant owed a bunch of money and wasn't going to go to a lawyer. But now everything changed, because now we've got lawyers out there who want to take these cases, who are going to be looking for these cases. We have lawyers that's going to go to the courthouses and look up files, just like Legal Aid looked up every one of the cases. And some lawyers are going to solicit these people. You know how it is. We're bottom feeders, right? Lawyers are bottom feeders. They're going to look for anything. When they see that they can make money off of the situation, that's what lawyers do. That's what a lot of people do. And this is no exception here. You got to watch out for this. This is not normal. This is not the normal tenant representing lawyers. This is going to be a new breed that are going to jump in and they are going to cause you a lot of havoc. So you got to dot your I's, cross your T's, and trust me. Trust me when I tell you to do it right, because I know what these people are doing, and because we know what's going on. When I say I'm friends with these people, I don't hang out with these people, but I'm friends with them on email, and we talk about things, and they're very good with us because we have a lot of contact with Legal Aid. Oftentimes Legal Aid does not fight one of our evictions. They will call us first. They will say, hey, I got a tenant. They need a little bit more time. What could you do? Can you talk to your owner? Can you talk to your property manager? That's the way we get treated by Legal Aid. If you don't have a relationship with Legal Aid, they'll file 20 pages of paperwork on you. And you don't want that to happen. We don't want that to happen. And we don't want to have a private attorney out there doing that. So now let's look at it. We've got non-covered properties. Okay, that's good. Then we've got the covered properties. Those are problems. Covered properties. What are the key dates for the covered property? July 26th is when the 120-day covered property thing ends. July 26th. So that means that the CARES Act affects covered properties until July 26th. So some of you are thinking, all right, July 26th, I could serve a 3-day notice. No, you can't. If the property is covered under CARES, you will have to serve a 30-day notice under the CARES Act. So normally you would serve a 3-day notice. but now you're going to have to serve a 30-day notice. So think about this for a second. Anybody doing the math? What's the earliest date you could file an eviction if the property is covered, a non-payment of rent eviction? Remember that, non-payment of rent. What's the earliest date you could file a non-payment of rent eviction for a property covered under CARES? Anybody know? August 26th. That's a long time from now. August 26th. So as you can see, covered properties are indeed a big, big problem. If you manage a covered property and the tenant doesn't pay the rent, you have to wait until August 26th before you could even file the eviction. So on July 27th or so, you would be serving a notice, and it can't be a 3-day notice. It has to be a 30-day notice. See, this stuff's getting confusing. If you're not a little bit confused, you might not be listening. On July 27th, you're going to be serving a 30-day notice. Then after August 25th, you will be able to go ahead and file an eviction for non-payment of rent, as long as the federal government doesn't extend this. We don't know what the federal government's going to do. We have no clue. This thing could get worse. The COVID situation could get worse, and everything could get turned upside down and go backwards. Now, what about other things? Non-compliances, non-renewals. Can you do a non-compliance eviction or non-compliance notice or a non-renewal on a covered property? And the answer is yes. So remember, it only applies to non-payment of rent. But if it's a covered property, the notices are going to be different. Instead of being a 7-day notice of non-compliance, it's going to be a 30-day notice of non-compliance. No late charges. And this is absolute law. No late charges can be assessed to anybody on any paperwork if they're on a covered property. No late charges. The law is very clear about that. Read the law. It's all on the website. Press the button, read the CARES Act. It's like, don't read the whole CARES Act. That's really long. But just read the one paragraph that really pertains to you. And then watch the videos, watch the explanations, and it's going to click. You're going to be like, okay, I got it. And it's going to be, it will be a lot easier to understand. So you can see you've got a problem. If the property is, in fact, covered, it's a mess. Hopefully, you don't have too many people that are not paying the rent right now, and all this stuff is going to be a moot point. That would be beautiful if you're in that position. Now, what about credit bureaus? Can you report anything to the credit bureaus right now? I told you can't charge people anything. You can't give them 3-day notices. You can't give them demands for late charges. You can't. We don't even know if you can give them a bad check letter. It says no penalties, no fees, no nothing. We don't even know if a bad check letter is allowed. That's how messed up the law is. So there's a question you could ask me, and I don't know the answer. But what could potentially happen? Sometimes your software programs will send things to the credit bureaus, and we have to be very careful that nothing gets sent to the credit bureaus. No bad credit is to be reported right now. Don't report any bad credit for anything that's going on that could be related to the situation that we're in right now. And we expect that there's going to be some law changes as to whether or not you're going to be able to even report any of this stuff to a credit bureau. Some of your software automatically reports stuff. Some of your software automatically generates letters. Do not do that. If you're going to send anything to your tenant, it's going to be, if you're on a covered property or if it's before June 2nd, you're going to use what's called a reminder letter. It reminds them, it tells them, this is how much rent you owe. Not all the other stuff, you're going to leave that off of there. This is how much rent you owe. You're going to be able to send that. You're going to tell them what they owe. You're going to use that reminder letter, no 3-day notices. Be very careful that you don't accidentally do that. I could show you a couple cases where attorney generals literally have come down and are suing our large apartment management companies because they serve 3-day notices. They didn't know any better, probably. They didn't know the law. They just did what they always did. What have we been doing for the past 30 years, 40 years? Tenant doesn't pay the rent, we serve a 3-day notice. But now everything's upside down and people didn't know about it. Well, ignorance of the law does not necessarily get you out of trouble, and you all know that. What about repairs? You've got floods. You've got essential repairs. Let's say you got an essential repair. If you have an essential repair, of course, you have to still fix things. And, I get a question every once in a while. People will say, well, if the tenant's not paying the rent, do I have to make a repair? Look, I know it doesn't feel right to make a repair if the tenant's not paying the rent, but there's nothing in the law that says that the tenant has to be current in the rent in order for a repair to be done. Let's talk about essential repairs. You got an essential repair. Of course, you're going to send your people out. It's great if you have a third-party vendor to be able to send them out, because hopefully they're going to follow the safety guidelines and the personal protective equipment and all kinds of things like that. But suppose the tenant doesn't let them in. Suppose they refuse you access. That's when you're going to have to jump into action, call the police, sheriff's department, whatever, go over there and say, look, we have got to get in. There is a leak. Maybe it's a condo and it's leaking down from upstairs to downstairs. And the people upstairs, they don't realize there's a leak under the sink. It's not affecting them, but it's affecting the people downstairs. This is where you're going to have to just put your foot down, bring the police, get law enforcement involved if you have to. You just can't barge your way in. If they say you can't come in, you can't come in, but that's where you're going to get law enforcement. What about non-essential repairs? Somebody calls you up about something non-essential. They say, a burner on the stove isn't working, the microwave isn't working, something's not essential. If it's not, and you all know what, you've all decided what essential and not essential is, but if something's not essential, you still could make repairs if they let you in, and many of you are still continuing to make non-essential repairs, but the tenant might say, no, you can't come in. If the tenant says, no, you can't come in, what do you normally do? Well, if it's not essential and the tenant denies you access, well, you would say, oh, well, okay, well, let us know when we can come in. And then that work order gets shelved. Sometimes, though, that work order gets shelved for a long time. And this happened before the COVID thing. When a tenant refuses you access, let's say they do it a couple times, you get fed up and you're like, all right, fine. If they don't want to let us in to make a repair, we're not going to make a repair. It's not essential anyway. So it gets shelved. Then 2 months from now, 3 months from now, when the tenant doesn't pay the rent, now this is, let's say this is a good rent paying tenant, 3 months from now, they stop paying the rent, I file an eviction, and then there we go in court. There's the tenant screaming about how you didn't make a repair that they told you about 2 months ago or 3 months ago. And then you say, well, wait a minute, we didn't make the repair because you didn't let us in. You refused us access. And there they are looking at the judge and they go, that's outrageous. We did not refuse. You must be confusing us with somebody else. We did not refuse you access. Or maybe we did refuse you access on that day, but we just asked that you came back when we weren't there. Look, people come up with lies. People lie all the time. And some people can lie better than you can tell the truth. I've been in court listening to tenant stories sometimes, and I'm like, I'm listening to this, and I'm listening to my own client, and I'm thinking, I think my client's lying to me. You know how it is. People are good. Some people can lie better than you could tell the truth. Be careful. Use what's called a confirmatory email or confirmatory communication. Some of you communicate by email. Some of you communicate by texting. Some of you communicate by phone. Whatever you're doing, you're going to have to, when somebody denies you access for a non-essential repair, I want you to use what's called a confirmatory communication. And I have a sample of what that looks like. I'm going to give that to you, and you could fiddle with it, do whatever you want with it. Don't ask me to write up a form for you or fill it out. This is for you. You could fiddle with it, put your name on it, do whatever the heck you want with it. It's yours. It says something like this: Dear Mr. Tenant, on such and such a date, you requested that we repair X, Y, and Z. We came out to make the repair, and you denied our vendor access, or you denied us access, whatever the case may be. And there you go. You've got, and then it says, in the event you are going to allow us access, we will wait for you to tell us in writing. So you see, in a perfect world, you'd have the tenant just give you a letter, but they don't do that. They just say, you can't come in. And then you walk away and like, oh, well, I can't come in. But what you're doing is you're sending a confirmatory communication. You're telling them, we were there, you reported it, we were there, you refused to let us in. Now it's on you. So you have to come and tell us when you're going to let us in. Because tenants will play games like that. They play games when things are good. They play games when things are bad. And sometimes when things are bad, they play more games. So we have to be careful about that. People love to take advantage of situations. You know that. And in situations like this, it's not going to change. It's only going to get worse. Now, let's say you have a tenant who hasn't paid their rent. So you got a tenant, they're in non-rent payment status. What do? Well, you could sit back and do nothing, or you could communicate with them. And I recommend that you do communicate with them. Call them up on the phone, send them an email, send them a text, whatever way you're allowed to communicate. I don't know whatever, everybody does things differently. I highly recommend texting. A lot of people use Property Text Box or the texting program that's within their software. Communicate. So you're going to talk to your tenant and say, hey, what's the deal, bro? Where's the rent? Where's the rent? And you're going to get the sob story, right? Well, I lost my job, this, that, and the other thing. Some of it might be true. Some of it might be a lie. Who knows? Doesn't really matter, does it? It doesn't matter one bit. All it matters is this: you owe the rent. I need my rent money. That's where they might say, or you might say, what do you have? What do you have? What could we do? How could we work this out? How could we make this work for both of us? You don't want to threaten eviction because you can't evict them. If they're under cares, you can't evict them for a long time. If they're not under cares, if they're non-covered property, then you can't do anything until after June 2nd. So we don't want to threaten anybody, but you want to say, hey, what's the scoop here? Let's try to work something out so we don't have to evict you in the future. People don't want evictions on their records. It sticks on their records forever. So then they make an offer. They say, well, I could do this, I could do this, I could pay this, I could do that. And that's where you're going to say, all right, well, I need to take this to my owner. And I'm a really big proponent of having your owner make the call, make the decision, not the phone call, make the call on whether or not you're going to do a deal. I don't like when property managers do deals without owner's permission. Now, some of you say, Harry, I got the best property management agreement in the world. I can do whatever I want. All right, good. Go ahead, make a deal with the tenant. Make a deal with the tenant, and then the tenant doesn't follow through. And then how are you going to look to that owner? So I don't recommend it. I recommend that if you're going to make a deal, you're going to ask the owner to give your permission. I've got the form that you're going to send to your owner where they're going to grant you permission to make the deal. I don't like it. I've seen property managers make deals with tenants in the past where on maybe security deposit payment plans, I've seen them wait to get rent money when maybe a tax return comes in. I've seen property managers do all kinds of things only to get burned really bad when the tenant doesn't pay. And then they look really, really bad because the owner says, I never gave permission for that. I never told you you could hold off for those 15 days. You see how that works? It's very dangerous. So that's why we like you to get, it's my personal opinion. I like you to get permission from the owner of the property. I don't care how much power you have in your property management agreement. You've got to protect yourself for when things go bad. And many payment plans go bad. They do. They look good. And for inexperienced property managers get fooled all the time. They think that the tenant's going to do what they say they're going to do. The truth of the matter is, a lot of times the tenants don't do what they say they're going to do. But if you're naive, if you're inexperienced, you're going to fall for it. So that's a business decision that you guys have to make along with your owner as to what you're going to do. Now, what about using a security deposit or a last month's rent right now? Your tenant owes a month's rent or 2 months' rent, and they are in terrible shape, and your owner is desperate. Your owner is desperate for money. You're holding a security deposit. You're holding a last month's rent. Can you tap into that? Can you use that money? The answer is yes, as long as the owner and the tenant agree. And I've got the form for that. It's sacred money. I always tell people that money's sacred. That money belongs to the tenant. No matter how you feel about it, that money's the tenant's money. But you can agree. You could do anything by agreement. You could agree with the tenant that money will be used for right now. And maybe the owner needs the money. Maybe the tenant's in bad shape. Maybe you're holding last month's rent and a security deposit. Maybe you're just holding a security deposit, whatever. But you can use that. You can touch it right now if you use the proper form. Never do it verbally. You're going to use the right form. So you can tap in to that money. There's nothing wrong with that, other than the downside is that if you tap into that money, you're not going to have that money. And if the tenant doesn't leave, or if you have to file an eviction, you're not going to have it. Or if they do damages to their property, you're not going to have any money. So obviously there's a downside to it. But the upside is if you're desperate for money, at least the money is there. So those are some of the things that you can do, tap it into the deposit. And then there's one other thing that some of you don't like to talk about, but it's a possibility. There is a thing called cash for keys. If you've got a tenant who is causing you problems or who owes a bunch of rent money, and you've got an owner who needs that place vacant for whatever reason, maybe they're selling the property, and you got a lot of people that are trying to sell properties, and a lot of people are having trouble selling them because the tenants aren't letting them in for showings. And how do you deal with that? If they don't let you in for showings, what are you going to do? You're going to force your way in? Of course not. You can't do that. And then the owner up in New Jersey, he's angry. He's like, well, I don't understand it. The tenant's not allowing the property to be shown. I want you to do something about that. Well, what the heck are you going to do about it? If you were to go in front of a judge right now and the tenant says, Your Honor, I didn't want them in my house. I'm afraid of COVID. I had my elderly mother. I visit her on the weekends. I'm trying not to be exposed to anybody. I'm doing everything I can to stay away from people. I didn't want. So you got a problem. What do you think a judge will do? What do you think? You know what a judge is going to do. The judge is going to side with the tenant. But now what do you do when you've got that property where you need it? You need it bad. The tenant owes rent. The tenant, cash for keys. Cash for keys. I know it sounds abhorrent. Nobody likes talking about it. It sounds horrible to pay somebody to leave, but man, sometimes it's the best thing you can do. I've done it myself with my own personal property. I had a situation a couple years ago, a terrible tenant. Turned out it was a nightmare. My property manager made every mistake in the book, unfortunately, put somebody in. It was the worst. Normally I would file an eviction, but I didn't want to do that because the tenant already had an attorney because she had a criminal problem going on. And that attorney already indicated he was going to give me a hard time. So I said, all right, here's the deal. I'll give your security deposit back and I'll let you live for this month. Don't pay me any rent. So there we go. 2 months rent down the drain. But guess what I accomplished? I got rid of her. I didn't have to hire an attorney. You might say, well, Harry, why didn't you do it yourself? It's not a good idea to represent yourself. That's why I didn't even think about that. I'm not going to do that. But here we go. I paid that person to go away and I got exactly what I wanted. And it was I'd rather give a tenant $1,000, $2,000 to go away than pay $5,000 to an attorney where it's not guaranteed. But you need to learn how to do cash for keys too. Don't get fooled. I've seen people do cash for keys and they give the cash to the tenant before the tenant's out of there. Oh boy, you could have some serious problems when you do that. So quick review. We're going to go backwards a second. What are you going to do? You're going to find out if your property's covered over here, not covered over here. So covered is a problem. That's going to be a big problem. Everything changes. Your non-covered properties are going to be much easier to deal with for everything, for non-compliances, for non-payment of rent if they're non-covered. As I said before with the showings, if you have people denying showings and you call me up and say, Harry, what do I do? We could give the tenant a notice, but good luck trying to show a property. Some of you are learning about self-showings right now, something that I used to not like years ago when it first came out. I was totally against self-showings, but my opinion's changed over the years. Self-guided tours, self-showings, all that stuff works out good. Also, this is the time to think about using companies like On-Site Pros to allow you to have a third party be doing the inspections that you need to do, to be able to, anytime my clients use third party inspectors like On-Site Pros, and dropping their name because they're a member of NARPM, very active member, they hardly ever have security deposit disputes because they're a third party and they do it right and they know how to do it because that's all they do. Just like you're good at what you do, they're good at what they do. So a lot of this stuff's a little bit overwhelming. I spit out a lot of stuff. I've been talking for almost an hour. If you have any questions, though, the best thing you need to learn how to do is stop. Just stop. Think about that stop sign. Think about the first time you had somebody die in a rental property. You discovered them and they're dead. And it was a horrible experience. And all of a sudden, friends and relatives appeared and they wanted to be let in or they wanted the keys and you didn't know what to do. What hopefully did you do? You stopped. What happened when you had a house fire? What happened when you have a shooting at a property? What happened when you have a big drug bust? Well, you could figure out what you're going to think about what you can do and do something, or you could just stop. The beautiful thing about this business, and this is different than so many other businesses, property managers, you guys are so spoiled, it's not even funny. Property managers, lawyers like me who do evictions and prepare leases and things like that, generally speaking, we don't charge for answering questions. And that because we make our money off of the leases and off of the evictions. So if you know that you have a lawyer that doesn't charge you for asking questions, and you don't ask the lawyer a question when something new pops up or something bizarre or something you've never dealt with, you are selling yourself short. You are really selling yourself short. And you also know this, especially with me, if you do something without checking with me first, if you make some decisions, like you call me up and you say, Harry, I've been dealing with this mold problem. It's been going on for 3 months. And you got to see me get fired up. I'm like, it's been going on for 3 months. So when did they first complain about that big leak? Oh, 3 months ago, but we've been trying to work it out and we put them in a hotel for 3 days and we did this and we did that. Guess what? I'm not going to be there for you. I'm not going to help you. You'll be like, Harry, you're going to desert me? Yep. I'm going to desert you. You're going to have to hire another lawyer because I don't take those kind of cases. I'd like you to call me up when you're not sure what to do and the problem just began, and then I will spend hours walking you through and guiding you through a process. And you need to learn that in every aspect of your business. Don't do things out of what you think is the right thing to do. Find out from your fellow NARPM members, find out from me, find out from whatever resources you have available to you. Don't take chances of doing things, especially when we're dealing with this stuff, which is new. I don't have all the answers. I used to think I had most of the answers, but now when we're dealing with this stuff now, that we have a lot of questions. I could write down about 10 questions and show them to you and tell you that we don't know the answer to these things. And that's very frustrating to not know an answer. When you don't know an answer, you have to be extra careful. So you're going to, hopefully, when you're dealing with these situations, you're going to stop. That big stop sign's going to pop up, and you're going to say, I don't know what to do. I'm going to check. That's what a professional does. A professional doesn't assume. They don't just act and blurt out something or do something or throw a notice at somebody or grab a form. They find out what to do before they do it. And I can't tell you how important that is right now more than ever before. Keeping in touch with NARPM, reading the emails that you get, watching the website and seeing the alerts that we get. The stuff is really important. We don't even have it yet on our website about June 2nd. It just happened. It's going to be there later. If you hear a rumor from somebody, confirm. If you read something on Facebook, it could be from somebody from another state. Laws are different in every single state. Every single state is different. Florida, actually, we're in one of the greatest states out there. The laws are very pro-landlord, and they're very fair too. They're not outrageously anti-tenant. They're actually very pro-landlord and very fair. And we want to keep them that way. And that's what associations like NARPM, Florida Association of Realtor, Florida Apartment Association, that's what they're doing. Our members, 2 members of NARPM were at the table, so to speak. It was a virtual table. They were talking with the governor about this whole thing. They were acting for your interests to make sure that the governor didn't extend this too far. FAR was there doing the same thing. The Florida Apartment Association was there doing the same thing. And the only way we accomplish anything is as a group. If you didn't have the Florida Apartment Association out there covering your back, the laws in Florida would be mind-blowing. They would be so bad. Over the years, countless things have been killed by the Florida Apartment Association, but you didn't even hear about it because it was killed before it got anywhere. And that's why we're trying to build NARPM, get NARPM to be strong. And you should be strong in NARPM. You should also be strong in your association of realtors as well. If you guys have a property management committee at your association of realtors, I highly recommend that you're involved in both of them, because this is when we need power. I hear people complain all the time. They say, Harry, they just passed this stupid law in my city, and I can't believe they did this. Now we have to do this. We have to register. We got to do that. And I'm like, well, did you know they were going to pass that law? And we're like, no, we didn't even know about it. Well, there you go. Whose fault was it? If you don't keep up with this stuff, if you sit back, bad things are going to happen. And we see these bad things happening. So you really have to get involved. If you're serious about this business, if you're serious about your profession, you're going to get involved. Now, I want to mention something, the very last thing. I'm getting a bunch of questions about this, and I don't know the answer to it. I'm getting questions like, okay, we've got a person, and we know that this tenant had COVID-19, and they vacated, they skipped out, or they were non-renewed, or they left, they just left. Do we need to sanitize? Do we need to disinfect? I don't know. I don't know the answer. I don't know the science. I don't understand the science. They say, do this, do that. Don't do this, don't do that. Wear this, wear that. Don't go here, go there. I don't know what to do, but I do know this. We've got people in the association. Today, you heard from people who take care of that stuff, to take biohazard things and bodily fluids and cleanups and odors and all that stuff. We're going to find this information out, and we're going to find out, is it necessary? If it is necessary, who can do it for us at a reasonable price? Insurance issues. You heard Brian talking about insurance. There may be insurance coverage for some of the stuff that's going to happen right now, but we're not going to know until we examine these policies, and you have a professional examine these policies, not me. I'm not an insurance professional. I don't even understand my own insurance policy. You need professionals, and that's what we are. We're a group of people, group of vendors, group of professionals, and when we don't know an answer, we reach out even farther to figure out what to do. What do we do about this? Do we disinfect a place? Do we sanitize a place? If we don't sanitize a place, are we going to get in trouble? Suppose we do go in. Can we be held liable if we do a repair? Can my vendor be held liable for doing a repair? These are all questions that are popping up. And we've got some forms regarding liability, but I can't tell you whether they're going to hold up or not. I have them, I give them out to you, but just like things like pool clauses and liabilities for things like that, we don't know whether they're going to hold up. So this is where it's a moving target, where we're trying to figure out things as we go along. And it hasn't really been a long time when you think about it, and this all really began not that long ago, where it all started to hit the fan. But just stay in touch, stay close to the professionals, be a professional if you're not a professional, and learn what's going on. And we're going to get through this mess as a group, figuring it all out and figure out what the best approaches are. And that's a big question I've been getting right now, because people are vacating, and then you want to rent the house out. What would it, just like if somebody died in a house, and you ever rent out a house where somebody died in it, and then the new tenant freaks out because they found out somebody was killed in that house or they died in that house? Well, are we going to have to disclose that somebody had COVID? I don't know. All this stuff is starting to change and all happening. You heard one of our vendors was talking about how there's going to be some sort of standards for cleanup and things like that. We don't know anything right now. It's all, we play it by ear, one step at a time. And then, like I said, the stop sign. You're not sure, don't do a darn thing. Just hold back and try to get your questions answered. If you guys had any questions during this class, I hope you put them in I don't know whether they were in the question section or the chat box or whatever. Also, if you're not a NARPM member, join up. It's crazy not to. To me, it's insanity. If you want to be around the winners, you're going to join the association. And I know if they join today, they get $50 off. I know NARPM does that for every one of my classes. They let the people the new members get $50 off. So if you're not a member, join up. Dan's got the link, I'm sure, or you could go to narpm.org. But serious people are in NARPM. So Dan, do we have any questions? Anything pop up?
Yes, sir. We sure do. Got some good questions. I'll go over these. I haven't scrubbed all of them. Some of them are situational, and I'll just read them verbatim. It says, I have a tenant who is a single mom with one child. Her lease is up June 30th, 2020. Is there anything with COVID-19 that I have to add when I write a letter to her that I will not renew her lease?
All right. What do you think my first question is? Is it covered or is it not covered? Okay, that's our question, right? Covered or not covered. But we're in May right now. We got to look at the lease, see how much notice is required. Your lease could require 30 days notice, 60 days notice. So we got to look at the lease first. I have an article on non-renewing the lease. I have a video, actually. I have over 200 videos. They're all free, 100% free. I got 200 videos that deal with all kinds of stuff that you deal with on a day-to-day basis. And one of them is how to non-renew a lease. And it goes through the steps. As far as COVID is concerned, and the CARES Act and the executive order, there's nothing in there that clearly talks about this situation. It's scary, though, because you could interpret the CARES Act. You could interpret the CARES Act as saying that you can't ask someone to vacate. And we're not sure. That's why we're bouncing this off all these attorneys all around the country to try. And we're trying to, the Congress is actually, Florida Apartment Association, National Apartment Association is getting Congress to try to give us clarification, because they do that. They will give us clarification on acts and laws. But we're not sure what to do right now. But I feel pretty comfortable that you can serve your notice of non-renewal. If it's a CARES covered property, it will have to be at least 30 days. No matter if your lease is 30 days or 15, it's going to be at least 30 days. And make sure your reason is not because they're not paying rent. Make sure you have a reason. I don't know what your reason is. The reason could be totally valid. They could be terrible tenants, or could be a situation where the owner wants to sell. Who knows?
Yep. Good. All right. Second question. I have a tenant with an NSF fee or check. Can I file in court?
No, don't do anything right now. First of all, how often does a property manager file on an NSF? The way you don't really file on an NSF. What you do is you send out an NSF letter. There's the civil letter and there's the criminal letter. So if I were you, I would just hold off on doing any of that stuff, because the law, as it's so poorly written, it says no penalties, no fees, and you could interpret the law as saying that an NSF fee is a penalty, which it is, right? and we don't know what you could do. Now, I want to clarify something too. I never once said the tenant doesn't owe the rent. I never once said the tenant doesn't owe anything. They owe it. They're not being forgiven. There's nothing forgiven yet. Nothing being forgiven yet. But as far as charging it, where you're actually giving them, charge it on your computer in the office, but don't be giving them anything, telling them that they owe it if they're a CARES covered property. And finally, I got to mention this because this is so important and I forgot. This is fairly new. The state of Florida and the federal government, they're going to start unleashing money onto state and local governments, organizations, institutions in the state and on the state and the local county, city and county level. This is so important. I'm so glad it popped in my head. I would have killed myself for not remembering to tell you about this. There's a lot of money. It's coming. You need to make sure that you know where it is, because the minute it comes, you need to know about this so you could tell your tenant. If you've got tenants who owe rent or sitting there owing rent money, then you want to be able to know, tell your tenants right away, hey, you need to go over here and apply for this, because there's going to be millions and millions, probably billions of dollars are going to be given. It's already in the works right now. The money's already starting to come out. It's going to be given to state, local, counties, cities, and this money is for rent relief, just like we have it now. You know, we have rent relief right now. It's just not a lot of money. And it's important that you are on top of this stuff. Call up your county, call up your city, and see if you can get the right person who's going to be involved in this so that when the money comes, you're going to know about it right away. Because what happens to money eventually? You run out. So all of a sudden, they've got $10 million of rent relief money in your county. And then anybody who knows about it's going to run over there and get that rent relief money, but you might not know about it. So then you don't get the money. Then you try to get the money and the money's gone. So this is some homework for you. You have, besides finding out whether your property's covered or not covered, one of your other big homework things is to really investigate right now and follow this money, because the money is coming. And this is a big thing that the Apartment Association is working on right now. They are watching this money like a hawk. It's already set, and money is about ready to be released for rental assistance. This is money that's going to come to you, but it's not going to come automatically. Your tenant's going to have to apply for it. So very important. I'm so glad I've remembered that.
Very good. All right, can we issue non-renewal of leases for all tenants, including the covered properties?
Yes, you can. Remember, the CARES Act applies to non-payment of rent. That's what it talks about, non-payment of rent. That's the purpose. The purpose of the CARES Act, the purpose of the executive order is for people who could not pay their rent. The purpose of the executive order, the purpose of the CARES Act was not to let people live for free forever. You still can non-renew people. You still can serve the notices, but the type of notice that you serve, that's where if you got a CARES property and you're not sure what to do, the best thing you do is shoot me an email, shoot me, Dave, Brian, we switch them, we pass them off to each other when they start coming in too heavy, and when we'll tell you what to do. That's the best thing to do. If you're not sure, you're going to find out. But you can non-renew people. Absolutely. And we have some evictions going on right now, non-renewal evictions and non-compliance evictions going on right now because many of the courts are open.
All right, situational question. Owner wanting to non-renew will give tenant minimum of 30 days notice, but what if the tenant hasn't paid rent in a while due to COVID-19? What's going to be the best way to collect from the tenant?
Collect? Look. If you're even thinking about collection from a tenant, then I'm not sure that you've been managing property for too long, because collections in Florida is very, very difficult. Our strongest collection tool is when we file an eviction against somebody and then they pay so that they don't get evicted. Once a tenant skips out on you or walks out on you, collecting that money is very, very difficult. And that's an expectation that a lot of owners have. That's one of the first things you need to do with your owners is when they have expectations that you're going to be able to collect from a skip or collect after an eviction. That's something that you should put in your property owner's handbook, the one that most of you don't have. But that's where you explain, this is Florida law when it comes to collections. It's tough. If collections were easy or even possible, even remotely successful, I would be doing it. because I got a built-in client base of thousands, and I could have a collection agency tomorrow. But the reason I don't do it is because the rate of collection is so minimal, so difficult. But they still owe it. They're not forgiven. Now, if somebody skips out, because this gets complicated, if you got, for instance, a tenant skips out, they were going to school. It's by the college. They were renting an apartment by the college, renting a house from you, and they're like, well, school's closed. I got 6 months left of my lease. I'm leaving. Can you go after them for that? Right now, the answer is yes. Are they going to change that? What are they going to do? We don't know what they're going to do, because you have to think about this. Millions of people are being affected by this right now, and millions of people potentially are going to get their credit trashed. And the federal government, trust me on this, mark my word, the federal government's going to step in and do something to protect these people that were affected in this period that we're in right now. But they still owe it. Don't send anything to collections yet. Just hold off on it.
Good. What if we have a non-compliance in an HOA that only gives 7 to 14 days to correct violation, but we as property managers have to give 30 days?
Like if it's a CARES property, for instance. So this is where you, as the property manager, needs to educate the association, educate the management company for this. This is where you've got it. I do it all the time. I have associations. I see the letters all the time. They say, you need to get your tenant out in 10 days. Well, how the heck are you going to do that? Your tenant has an unauthorized occupant. They must be removed in 10 days. Well, boy, I wish I could do that magic trick. So then you have to educate them, and you have to tell them, well, we can't do that. We have to do X, Y, and Z, and we are doing X, Y, and Z. And you communicate with the association. You calm them down. You let them know that you're on top of it. I deal with this constantly. The main thing is educating the people who don't understand the law. Associations, the association management companies do not understand landlord-tenant law. They figured they could tell you to get somebody out in 7 days, and you magically will be able to do that.
Mm-hmm. How do we handle rental verification request if behind on rent?
Okay, I'm not really sure what you mean.
That's all it says. I'm assuming they're referring to someone's applying for one of your rental properties. They may be behind on rent. We are requesting a rental verification. If it shows as if they're behind, should that property manager base a decision off being behind on, due to COVID-19?
Okay, so you're a property manager that's managing a home, and the tenant's behind on the rent, and you get a rental verification from somebody else? Is that what
Sounds
you're
like that's kind of the gist of the question.
Okay, yeah. Hey, do what you normally do. Look, I never said, there's nothing in the law that says they don't owe the money. Nothing in the law. There's no forgiveness in the law for this rent. They owe the money, and you could honestly say, yeah, I haven't received March's rent. I haven't received April's rent. I haven't received May's rent. Whatever the case may be, you will be able to do that. Don't try not to go overboard in thinking that somehow this is going to be a free pass for everybody. Could be someday, but as of right now, it's not. And any tenant who says that they don't have to pay the rent, they are dead wrong.
Mm-hmm. All right, here's a good one. So Wisconsin's lockdown was judged unconstitutional yesterday. Do Florida landlords have reasonable potential for lawsuits for the unconstitutional taking of property rights by the Fed, state, and county government?
Who knows? Ask Morgan and Morgan. I have no clue. I'm a landlord-tenant lawyer. That stuff is beyond me. I can't even understand that stuff.
Gotcha. After it passes, can late fees be charged for new rents and nothing prior?
After what?
After it all passes, after COVID's long gone, can late fees be charged for new rents and nothing prior?
Right. Well, right now, if it's non-covered properties, then everything is going to normalize on, we're hoping, June 2nd, or June 3rd. So after that, if I feel comfortable that you could charge late charges like you normally would on a non-covered property. If you're on a covered property, this is a really scary thing. I don't get into this because it gets way too deep. But just because the CARES Act has this 120-day moratorium on evictions for non-payment of rent, do you know the CARES Act does not end in 120 days? It keeps going. And I don't even want to go there because it can get really messy if we start getting deeper and deeper as to what's going to happen 2 months after July 26th or August 26th. We don't know. But the main thing is the late charges are going to take you down. They're going to alert the judge to things. Whenever we file our cases after June 2nd, we're going to give an affidavit to the court stating that, number one, it's not covered. We're going to make sure that the judge knows right up front it's not covered. We're going to allege that in the complaint or use an affidavit. And then what we're going to do is I'm going to make sure there's no late charges on those 3-day notices. You just don't want to, look, it's so bad. Why take a gamble and make it worse?
Yeah. All right. So if a tenant broke their lease and moved out of the property, are we permitted to keep their security deposit? If so, what kind of notice are we permitted to send to the tenant in regards to keeping that deposit?
You could do it just like before. And nothing has changed with that. When a tenant breaks their lease, you charge them what they owe from the security deposits. If someone breaks their lease in middle of May and they haven't paid May's rent, you would charge May's rent onto the security deposit, or you would wait until June 5th or June 10th, and then you'd send out the notice of intention to impose a claim on security deposit, and you'd charge it for May's rent and June's rent. There's nothing in the law right now that says that people were allowed to break their lease. And most of the time when people break their lease, most of the time they owe rent. So you're going to be able to just charge that rent and eat up the security deposit. In almost every case, that's the situation.
Mm-hmm. All right. So after June 3rd, once we serve a 3-day notice to non-covered properties, can we charge the $50 delivery of notice fee?
Oh, don't get me started on those notice fees. We don't even know whether notice fees are legal. There's nothing in Florida law that states that you could charge a notice fee. Now, many of your leases, even the ones that we prepare for you, you request it, we'll put it in there, and we'll say that it's $50 charge or $25 notice fee as additional rent. If it's a non-covered property, you probably could do it. But my feeling is this: if I were in your shoes, I would, and my tenant, my owner's tenant did not pay the rent, I would want to do everything I can as cautiously as possible to get them evicted. I would not take chances on doing anything that would jeopardize that situation. I just wouldn't do it. Some judges don't like that fee. They do not like notice fees. I've seen, I have some judges, there are a couple judges in Florida that will not allow you to put late charges on a 3-day notice, period, end of story, no matter what your lease says. So we don't know what we're going to be dealing with.
Yeah. Can we post reminder notices on the property, or must they be mailed?
Oh, excellent question. My reminder notice that I gave out, I have it. I don't have posting on there, and I did that on purpose. Now you could go post your notices if you want, but some tenants hit the roof if you go over right now. They don't want anybody by their house. They don't want any notices on their door. They don't want you going to their house. You could email it to them as long as you have, hopefully you used a permission-based thing for texting, emailing, whatever. You could let them know what they owe. But some tenants do not want you on their property knocking on that door. And either you respect that, or you mail it to them by old-fashioned mail, or you do it by email, by text. You know, most professional property managers are communicating through texting and email. Now, the law doesn't allow us yet to put 3-day notices, serve 3-day notices by email and stuff like that. But at least you can send your reminder or your whatever you're going to send, informational type notice, you could send through your normal electronic means.
Good. All right, a couple more here. Let's see. Just for clarification, it says, explain in a few words so I can post it on my wall. What can we do on June 2nd and what can we do July 29th?
Okay. On June 2nd or June 3rd, let's say June 3rd. On June 3rd, if you have non-covered properties, so you confirm that they are not covered, on June 3rd, you will be able to go out and serve your 3-day notices. And then after the 3 days, not including Saturdays, Sundays, and legal holidays, as soon as that ends, you'll be able to file an eviction just like normal. Now, if it's a covered property, you cannot serve a 3-day notice for non-payment of rent. you cannot serve any notice for non-payment of rent until after July 26th.
Yeah. There you have it. All right. Last one. If a tenant used their entire last month's rent that was collected and it was during COVID-19 to pay the rent and not her actual last month of living on the lease, is it considered paid?
Well, how did that even happen? If it's a last month's rent for October, how did they use it for May? Mm-hmm. They can't. The only way they could use it for May is if you allowed that to be done using where the tenant said, please use my last. So I'm not really sure how that all went down, because the tenant can't just dictate. The tenant can't say, hey, I want you to use my last month's rent that's for October. I want you to use it now for May's rent. The tenant can't dictate that. That would have to be agreed upon by everybody involved. So I'm not really sure how that all went down. If that was agreed upon, the tenant says, yeah, use my last month's rent for May. Well, then they don't owe May's rent. And now you don't have a last month's rent. And then when June comes along, they're going to owe June.
Yep. All right. One last one that came in. Are we allowed to proceed with short-term rentals of more than 30 days?
You know, I don't know. Dave and Brian are handling all the short-term stuff. They know all about that. I'm just going to throw the answer out, but I don't know if it's from what, anytime I get a short-term question, I'm going to give it to them. I think I heard them say if it's over 30 days, then it's okay. But under 30 days, it's not okay. But I do not know, and I don't want to give you bad advice. At Brian@evict.com or Dave@evict.com, they are totally on top of short-term. I don't do anything with short-term. I leave it to them.
Gotcha. While we were talking, or while you were talking, one of our participants posted a link to Executive Order number 20-94, which appears to extend the moratorium in Florida through June 2nd.
Great, send it to me. I don't know. I probably already have it, but go ahead and send it. If you have it, send it to Harry@evict.com, and in five minutes I'll be able to look at it. I'm dying to see it.
Yeah, I'll post that link here in the chat as well.
Great.
So, Harry, that's all the questions. Any final remarks from you before we close?
No, just thank you so much for having me. And like I said, you know, this is the time where the NARPM people are thriving right now. They're growing, they're expanding, they're using the opportunity that they have. And you know, you got to make something out of a bad situation, a good thing out of a bad situation. So just go for it. And like I said, join NARPM, be successful. It's up to you. Thanks.
Absolutely. Hey guys, again, my name's Daniel Rothrock. I'm the president here, and we appreciate you spending your time with us. It's a lot of information, and you know, as Harry has said, NARPM is an organization. We truly lean on each other. We thrive even in times of peril because we have one another. Education is definitely part of our DNA. So we look forward to meeting some of the new faces coming up. Certainly hope to get back to some of the physical meetings sooner than later, but thank God for technology because we can still learn to thrive and learn in these environments that we're given. So bless everyone. Have a great week. Have a great month. And we look to see everyone around. So take care.
Thank you.
Take care. Thank you, Harry.
Thank you.